For nearly a year, it appeared that one of America's most closely followed murder cases had reached its conclusion. Bryan Kohberger had stood in an Idaho courtroom, admitted to murdering 4 University of Idaho students, accepted 4 life terms with no chance of parole, and given up his right to appeal. The trial millions of people expected to watch was never held. There were no cross-examinations, no jury deliberations, and no explanation in open court of why the 4 were killed. Then, in late July of this year, that ending came apart. Kohberger filed a petition asking the court to let him take his guilty plea back. He wrote it by hand from a cell in Idaho's maximum security prison, and the court record listed him as representing himself. When this channel covered that filing, its legal grounds had not been made public, and 2 questions were left open: whether the court would appoint him a lawyer and what the petition actually claimed. Both have now been answered. On August 3rd, a private defense attorney in Moscow, Idaho, was told he had a new client. He had not read the petition. He had not read the case file. He had not spoken to the man whose name was on it. Asked about the assignment that morning, he said his first job was to set up a phone call, then read the police reports, then drive down and speak to Kohberger face-to-face. The route by which that lawyer was appointed is the part of this story almost no headline has led on, and it is the part worth understanding. This video covers what the record now establishes, what the petition says now that it can be read, and what has not been decided. On July 2nd, 2025, weeks before jury selection, Kohberger pleaded guilty to 4 counts of first-degree murder and 1 count of felony burglary.
2, murder in the first degree as it relates to the murder of Madison Mogen. How do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonsalves, how do you plead, guilty or not guilty?
Guilty.
Judge Stephen Hippler took him through it question by question. Kohberger said he was entering the plea knowingly, intelligently, and voluntarily. He said no one had coerced him. He said no one had promised him anything beyond the written terms of the agreement. He was asked whether he was pleading guilty because he was guilty, and he answered yes. He was asked about the lawyers who had defended him for 2.5 years, and he told the court he was satisfied with them. He also signed a written factual basis document admitting responsibility for the deaths of Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. The agreement took the death penalty off the table. In exchange, Kohberger accepted 4 consecutive life sentences without parole, plus 10 years on the burglary count, and waived his right to a direct appeal. Hippler imposed that sentence on July 23, 2025. Kohberger was moved to the Idaho Maximum Security Institution at Kuna, roughly 300 miles south of Moscow, into J Block. This unit holds high-profile and high-risk prisoners, including men on death row. 1 year and 4 days later, a new civil case appeared on the Ada County District Court docket. The petition Kohberger filed on July 27, 2026, asked the court to set aside his convictions and let him withdraw the plea. Its grounds are now public, and they are specific. Kohberger names his former defense team, Ann Taylor, Elisa Massoth, and Bicca Barlow, and claims ineffective assistance of counsel. He claims the plea was not entered knowingly or voluntarily, that it was, in his words, induced by unkept promises and induced by threats from his own lawyers. He claims they misrepresented what death row in Idaho would actually be like in order to frighten him into the deal, and made promises about life sentence conditions that did not hold: immediate contact visits, freedom of movement, employment. He writes that he was convinced actual guilt was not an important factor in considering the plea, that death row was imminent, and that he was advised to lie. Entering a false plea would be, in the phrase he used, a legal victory. And he claims his attorneys failed to disclose exculpatory evidence before he signed. That last claim is the one with a physical object attached to it, so it is worth being precise about. The petition points to hairs recovered from the murder scene. They were clumps found where Ethan Chapin's right hand had been photographed in Xana Kernodle's bed, held to the bed frame by dried blood, on the side of the bed against the wall. Kohberger's position is that this material was potentially exculpatory and was never properly put in front of him. Here, the record and the reporting need to be separated. According to reporting on the petition, an expert retained by Kohberger's own defense team did examine hair recovered from Chapin's hand and concluded it was morphologically consistent with Chapin's own reference hair, in other words, his own. Separately, Brent Turvey, a forensic expert formerly retained by that defense, has told Fox News Digital that the hair evidence was not Kohberger's and that everyone involved should be put under oath, starting with Ann Taylor and her legal team. Those are claims made outside the courtroom by people with a position in the dispute. No court has tested any of it. Whether the material is exculpatory at all and whether Kohberger was told about it are precisely the questions a post-conviction proceeding exists to answer, and they have not been answered yet. What the court did do is narrower, and it happened in 2 steps. On July 29th, Judge Hippler granted Kohberger's motion for court-appointed counsel under Idaho's post-conviction relief statute and directed the Idaho State Public Defender to appoint an attorney to represent him throughout the proceedings. In the same order, the judge dealt with a second motion. Kohberger had asked to proceed on partial payment of court fees, and the judge noted that filing fees do not apply to petitions for post-conviction relief in the first place. The second step is where it becomes unusual. The Idaho State Public Defender's office could not take the case. That office was involved in Kohberger's original defense, and the petition accuses the lawyers who ran that defense of misconduct. So the appointment went instead through the office's alternate counsel division, which exists for exactly this situation. When there is a conflict between the public defender's office and the person it has been asked to represent, the division finds, hires, and assigns a private attorney in its place. On August 3rd, that division assigned Gregory R. Rauch of the law office of Magyar, Rauch, and Thier in Moscow, the same town where the murders happened. A review of court records shows Rauch has been assigned to 7 other post-conviction petitions across Idaho this year. Reached by the Idaho statesman, he said he was getting up to speed and had nothing to comment on. So the man asking to unwind a conviction obtained through the state public defense system now has a lawyer paid for by that same system, hired through the arm of it built to handle its own conflicts. It is worth stating plainly what the appointment is not. It is not a finding that Kohberger's claims are credible. It is not a ruling on the petition. It is not a new trial. And it does not reopen the murder case. His 4 murder convictions stand. His burglary conviction stands. 4 consecutive life terms without parole, plus 10 years, all stand. Nothing about his custody has changed. The appointment establishes one thing, that his claims will be presented to the court by an attorney rather than in his own handwriting. One part of the petition can be set against something already on paper, and it is the part about prison. Kohberger claims that his lawyers sold him a version of a life sentence that did not materialize, promising contact visits, movement, and work, while painting death row as unbearable. What the Idaho Department of Corrections' own records show is a man who began objecting to his conditions almost immediately. Documents obtained by People show that on July 30th, 2025, his second day in J Block and a week after sentencing, he asked to be moved to a different unit, complaining of minute-by-minute verbal threats and harassment, and of prisoners flooding their cells. Within the following week, he handed a guard a handwritten note reporting that another inmate had threatened to rape him, and reported a second inmate's crude sexual remark. He filed a sexual harassment complaint. Long-term prisoners in that unit are held in single cells, moved in restraints, given 1 hour outdoors a day, and a shower every second day. None of that establishes that anyone lied to him. A defendant being unhappy with prison is not evidence that his lawyers misdescribed it. But it does mark the point where his account of the deal and his lived experience of it began to diverge, and it began within days of the sentence being imposed, a full year before he wrote the petition. The standard those claims will be measured against is steep, and the reason is the July 2025 transcript. Kohberger gave up his direct appeal in the plea agreement, but post-conviction relief is a separate action governed by Idaho Code Section 19-4901, and it is not something a defendant can sign away. That principle has an Idaho case behind it. Garza against Idaho, decided by the United States Supreme Court in 2019, held that certain Sixth Amendment claims survive an appeal waiver. Idaho law also allows a court to set aside a conviction after sentencing to correct what the rule calls a manifest injustice. But a court weighing whether the plea was coerced starts from a hearing in which Kohberger was asked on the record whether he had been coerced and said no. Legal experts speaking to CNN, USA Today, and others have consistently used the same phrase for his position, an uphill battle, and several have pointed out a consequence that survives even success. If the plea were withdrawn and the case went to trial, the jury would still hear that he had already stated under oath that he was guilty. That admission does not disappear with the plea. There is also a clock. Under Idaho law, the window for post-conviction relief closes a year after the 42-day direct appeal deadline expires. On the Idaho Statesman's analysis, Kohberger's deadline falls in the first week of September this year. That is why the handwritten petition arrived when it did, and why the next filings will not take long to appear. The reaction to all of this has been consistent since the petition landed. The family of Kaylee Goncalves said Kohberger admitted his guilt and chose not to leave his fate or the facts of the case to a jury. Christy Goncalves has said the family is prepared to go back into court if he succeeds in reopening it. Idaho Attorney General Raul Labrador said his heart goes out to the families of Madison, Kaylee, Zana, and Ethan, and that his office stands ready to do whatever is necessary to see justice fully carried out. The Office of Ann Taylor declined to comment on the allegations. The Latah County Prosecutor's Office declined, citing pending litigation. By the Statesman's accounting, the case has already cost Idaho taxpayers more than $8 million, of which nearly $5.5 million went to Kohberger's public defense. What the post-conviction proceedings will add is not yet known. So, as of August 8, 2026, here is what is established. Kohberger now has court-appointed counsel for every stage of the post-conviction process, granted by order at the end of July. His lawyer is Gregory Rauch, a private attorney in Moscow, brought in through the alternate counsel division on August 3rd because of that conflict. The petition's grounds are ineffective assistance of counsel, a plea alleged to have been induced by unkept promises and by threats, and exculpatory evidence alleged to have been withheld. Kohberger's sworn answers at the July 2025 plea hearing, which contradict the petition point for point, and which any court reviewing it will have in front of it. It is not confirmed whether any of the petition's allegations are true, if the state will be ordered to answer, or whether the court will hold an evidentiary hearing, whether it will dismiss the petition without one, what Rauch will do with it. As of his appointment, he had not yet read the file, and an appointed attorney may amend a petition, narrow it, or find that the record does not support it, which leaves one date worth holding on to. Kohberger's statutory deadline for post-conviction relief falls in the first week of September. Before then, the petition either gets taken up and rewritten by the lawyer now holding it, or it stands as the document a prisoner wrote by hand in J-block. The filings that answer that question are weeks away, not months. When they are on the docket and can be read, they will be covered here from the documents, not from the reporting about them. Thank you for watching.